One of the things I think is interesting from my perspective, and the clients that Sarah and I counsel, is that we've really been in a period for probably the last 4 to 5 years of essentially hand-to-hand combat between corporates and their investors in terms of what needs to be disclosed where about climate. So, I do think there's some potential that the SEC process can start to bring some order to what is the floor. But Sarah's absolutely right that that's not going to be the ceiling. And I think it'll be an interesting time for companies to think through how their disclosure stacks up, how it meets both what the legal requirements will be, but also the continued process of thinking about what your climate disclosures and what your climate risk management looks like as against your peers. But Sarah, we've made this sound like it's perhaps a little bit far off. You said 18 months for a rule, but the SEC is also doing a lot of things right now that could cause some trouble for companies before the final rule comes out. I'm curious about your perspective on the directive that's been given to CorpFin to engage in enhanced reviews on climate disclosures, and also what's going on with examination priorities this year.
Sure. So I think these are some of the more interesting developments, really, quite frankly, because I think the rules that we ultimately get are probably going to be pretty principles based. So there's going to be, I would expect, a fair amount of flexibility in them. I think where the real edge lies here is with respect to enforcement and potential actions brought by the SEC to inquire about companies' processes around their climate disclosure. So what could that potentially look like? That could potentially look like the SEC comparing disclosures that are made in your publicly filed documents with the SEC compared to your website. It could involve them digging into, if you say that your board oversees matters with respect to ESG, them presuming that there are that means that there are ESG matters that are material to your company, and asking whether or not your risk disclosure in particular is up to snuff. I think on the enforcement side, we're seeing the SEC start with the financial sector, which makes, I think, in some ways, a lot of sense with respect to financial products that claim to be sustainable or use, kind of code words, right, for green or ESG. I think what's interesting to me in that space, Maggie, is that the SEC is doing that really before tackling perhaps the harder question of answering that question for themselves. So why does the SEC not have a green taxonomy around what does it mean to be sustainable before asking companies, asking public companies to define that, and asking about the gaps between, financial products, selling financial products that claim to be green, and saying that they're less green than they're claiming to be. To me, it's an interesting approach, and I'm wondering why a little bit the SEC has not tackled the taxonomy issue. I'm wondering what your thoughts are a little bit on that.
Yeah, so I think the taxonomy issue is an interesting one. That is clearly the approach that we are seeing in Europe. And I think there are a couple of potential reasons for not doing that here. The first is, if you look at the European experience, it has really bogged down, right? They are having these long protracted fights now about things like, well, what are nuclear and natural gas? Are they transition fuels? Are they green technologies? How do you think about that? And I think in many ways, one of the things that's resulting from that is a form over substance, right? So busy in putting everything into a taxonomy that maybe you're missing some of the other pieces. One of the things that we talk a lot about when Sarah and I are doing these kinds of ESG workshops is the extent to which ESG should really be a tool for creativity. What companies are saying and doing in their business continuity planning in light of physical climate risks, which is really interesting, because I think a lot of the dialogue that we've had with investors, that corporates and investors have been having over the last 4 or 5 years, has been about the transition risk. So, if you're an oil and gas company, can you become a carbon management company or a company that sells renewable energy? But the SEC is clearly very keyed in on the physical climate risk piece, which I think is really smart. And frankly, it's a much harder question for a much broader range of companies. What should boards be doing in the climate and ESG space from a reputation management or stakeholder point of view?